Autonomy Committee. Some members will be attending this morning's meeting via Starleaf, and our witnesses will be briefing us via Starleaf. Recording of the meeting will be made available on the committee's webpage on the Assembly website, and the meeting obviously will be broadcast live. And just to remind members to mute their tablet devices when they aren't speaking. Moving on then to item number 1, which is apologies. There are no apologies.
No, Stuart will be joining us later on.
And then moving on to item number 2, draft minutes. There is a copy of the draft minutes at page 5 of your pack. Are members content that those are an accurate reflection of the meeting?
Great.
And then there is a copy of the draft record of decisions that we took by correspondence for the meeting on the 25th of August at page 12 of your pack. So are members content with the record of decisions? Okay, so moving on then to item number 3, Chair's business. At page 20 of your pack, there is a clerk's memo on the informal meeting that was held with the aerospace industry on the 8th of July. Issues discussed included airline recovery, sustaining existing routes, and opportunities for new routes. The sector is calling for support for the job retention scheme, investment in research and development, and resolution of protocol issues impacting on importing materials. Arrangements are being made for an informal meeting with the chief executives of the local airports. So if members are content to note the briefing there just for the time being, and it's something that we will return to. Okay. So moving on then to page 26 of your pack, there's an infographic outlining the remit of the Smart Nano Manufacturing Corridor Consortium. At last week's committee meeting, obviously at Queen's, we were given a tour of the university's nanotechnology centre. So that information they had said they would share with us, and so it is just for our members to note. And then moving on to the third item of Chair's business, the committee was due to hold a joint briefing with the Education Committee on the 14 to 19 strategy last year, and that was postponed. So there is now a new date for the joint briefing being proposed, and that's the 20th of October. So are members content for the clerk to make arrangements for that joint briefing?
Thank you.
That's great. And then just to highlight to members that the following briefings today and all of our briefings in relation to the Parental Bereavement Leave Bill will be Hansarded, as is protocol in relation to bills. Okay, so moving on then to item number 4, which is our briefing from RAISE on the Parental Bereavement Leave and Pay Bill. There is a RAISE research paper at page 30 of your pack, and if I could just ask Tommy to bring into the spotlight for us Michael Scholes, who is a research officer here in the Assembly, Rachel Keys, who's also a research officer, Orla Drummond, who's a research officer, and I'll hand over to yourselves, who I can't see.
They are there.
Oh, they are there. They're not on ours. So if I hand over to yourselves to make an opening statement, and then we will open it up to members to ask some questions.
Thank you, Chair. I'm going to make a start. I take it you can hear me okay and see me? Yeah?
Yeah, we can indeed.
Great. So before I start, I'd like to thank Eleanor Murphy for her contribution to the paper. I'm going to summarise the key points of the paper and then hand over to Orla, who's going to discuss the equality implications of the bill. Then Rachel will discuss the financial implications, and that should then leave us plenty of time for questions. So the paper really aims to support the committee and indeed the wider Assembly in its scrutiny of the Parental Bereavement Leave and Pay Bill. Throughout the paper, we have presented, as we normally do in our papers, issues or questions for the department or indeed sometimes other departments in blue boxes. So starting at section 1 of the paper, it really provides an overview of the bill and of the public consultation that was held last year. So the bill was introduced, as you know, in June. It creates a statutory entitlement to leave and pay for working parents who suffer the death or stillbirth of a child. The bill mirrors provisions already enforced in GB. It entitles employees to both statutory bereavement leave and pay, and workers only to statutory bereavement pay. Individual employers are free to go beyond these specified entitlements and offer enhanced bereavement leave and pay benefits if they wish to. The bill contains powers that allow for the introduction of regulations to implement the leave and pay entitlements. For example, such regulations are to define a bereaved parent, reflecting, as the bill states, the caring relationship between the individual and the child prior to the child's death. Now, in relation to commencement, the bill specifies that commencement powers are not only conferred to the Department for the Economy, but also on the Department for the Communities. And the Minister anticipates that the leave and pay regulations could be introduced by the Department by April 2022. So Section 2 of the paper concerns the parental bereavement leave provisions of the bill. So bereavement leave is available to employees, not workers, from day one of their employment. It is offered only within 56 days of the child's death. It is to be taken in weekly blocks, not single days. It is provided up to a maximum number of days as specified under the regulations that the Department will bring forward. It is to be taken in accordance with specified notification requirements, again, which are to be brought forward by regulations. Okay, so then Section 3 concerns the pay elements of the bill. And really to sum up the bereavement pay aspect, it is offered to employees and workers after 26 weeks of their employment. It is to be taken at a pay rate to be specified under regulations. Now, currently in GB, this is £151.97, or 90% of an employee's average weekly earnings, whichever is lower. And employers can claim the statutory bereavement pay from HM Revenue and Customs, or a certain element of it. Section 4 then presents a summary of statutory pay and leave entitlements for working parents outside the UK. For example, Australia, the Netherlands, Norway and Sweden all provide paid leave for the care of non-family members. And in New Zealand, the Holidays Act 2003 contains provisions that confer minimum statutory entitlements to bereavement leave and family violence leave. The Holidays Bereavement Leave for Miscarriage Amendment Act 2021 amends the New Zealand 2003 Act to include provisions relating to miscarriage. In the Republic of Ireland, despite previous attempts to legislate, there is no statutory entitlement to bereavement leave and pay. This remains largely at the discretion of the employer. So Section 5 then of the paper provides a discussion of equality and human rights considerations. For example, the criteria for entitlement could impact on low-paid families if they feel unable to take periods of unpaid absence. Now, Orla will provide more detail on this and other equality considerations in her presentation. Section 5 also presents a consideration of financial implications of the bill. Under the current financial arrangements under the devolution settlement, Northern Ireland can extend bereavement leave and pay entitlements beyond those that are currently offered in GB. However, doing so would depart from the parity principle, which potentially could impact the Northern Ireland block grant and in turn the executive budget. There are also one-off and recurring costs to the public purse and for businesses, and Rachel will give more details on these in her presentation shortly. That's the summary of the key points of the bill paper, and I'm now going to hand over to Orla, who's going to discuss potential equality and human rights implications of the bill. Thank you.
Thank you, Michael. I'm going to cover three key issues that are documented in Section 5 of the paper, and that's page 70 in your pack, namely human rights and equality, the employment status of claimants, and then I'm going to look at parental bereavement pay and the parity principle as well. So in relation to human rights and equality, there are a few issues which could require further consideration and exploration. One such issue is the need for clarity in identifying who is actually eligible to claim. Essentially, a lack of clarity could impact the rights enshrined in the European Convention of Human Rights. In particular, Article 8, which guarantees protection of the right to respect for private and family life, and Article 14, which prohibits discrimination. There's also potential impacts to Section 75 of the Northern Ireland Act of 1998 in respect to race and religion, and also to gender. So during the consultation process, respondents called for recognition of different definitions of parenthood and family. In particular, they highlighted the need to ensure equal rights for unmarried parents, for those in same-sex relationships, and also those in informal kinship care arrangements. So as noted in the paper, kinship care is the full-time care of a child by kin other than a parent. So it could be a sibling, a grandparent, an aunt or an uncle. These informal arrangements are often born from crisis within the family setting. They're not recognised foster carers, and indeed the arrangements may not be known to social services. It's important to note that there have been recent judicial review cases for other bereavement benefits. So, for example, the McLaughlin case of 2018 related to the widowed parents allowance. And this was a social security benefit payable to men and women with dependent children who had been widowed. And in Miss McLaughlin's case, she had 3 children when her partner had died. But as they were not married, she was deemed ineligible for the allowance. And she sought judicial review, and it went the whole way to the Supreme Court. And they found that it was contrary to Article 14 of the European Convention on Human Rights when it was read with Article 8 and Article 1. So this case highlights why it's so important to scrutinise who is eligible to claim. Clarification helps to provide guidance for employees and employers, but also helps to limit the potential for judicial review cases going forward. So it could be beneficial to examine if this issue has given rise to any consideration within the GB context. Another area for consideration is race and religious discrimination, and this issue was raised by a number of GB law firms as a potential problem going forward. They noted that certain religions have specific observances on the death of a child, and this would have greater weight within the law here due to Section 75 of the Northern Ireland Act, and therefore could require additional scrutiny. Another consideration is gender and the socio-economic impact of the bill, particularly in relation to the qualification for parental bereavement pay, which only commences following a 26 weeks of employment. This could be particularly impactful for low-paid families who may feel they're unable to afford an unpaid period of absence, and it may also have an inequitable impact on women who are more likely to be in low-paid employment. So the Living Wage Foundation notes that women make up nearly 2/3 of workers struggling to make ends meet on less than the real living wage. Women may be unable to avail of unpaid leave due to caring or financial responsibility, and this may indirectly impact Section 75 in respect to gender equality. There was a suggestion during the consultation process for the provision of a statutory payment for bereaved parents that fell outside of the 26-week qualifying period. And this could potentially mitigate the impact to Section 75 if that was made available. Very briefly, it's also important to note the difference in employment status between an employee and a worker. So a worker is by definition a hybrid of an employee and self-employed. Workers generally have fewer protections in domestic employment law. So in the enactment of this bill, workers could be treated differently in relation to bereavement leave entitlement. Even looking within our own environment, we can make a comparison for those who are employed by the Northern Ireland Assembly directly as an employee, and then agency staff. So employees have entitlement to annual leave from day one, where agency staff would have to accrue that going forward. So that's just something to keep in mind as well. Finally, I'm just going to chat about the parental bereavement pay and the parity principle. So the consultation highlighted the desire to mirror the leave and pay provisions that were introduced in GB in April. That aim is in keeping with the parity principle in relation to social security, child support and pensions as set out in Section 87 of the Northern Ireland Act. So Section 87 requires Minister and the Secretary of State for Work and Pension to consult and ensure that relevant legislation achieves a single system across the UK. Yet Section 87 does not explicitly place a requirement to always maintain parity, and there have been cases where there has been a disparity of approach. So, for example, the provision of welfare supplementary payments to mitigate against bedroom tax and the benefit cap, and this funding is derived from the NI block grant. So during consultation for the bill, responses called for an increase to the parental bereavement pay currently provided in GP, namely that it should be available from the first day of employment and parents shouldn't have to wait until the 26-week qualifying period. Deciding to do that would impact the Executive's block grant, with Treasury seeking to recover additional costs. There was a consultation with HMRC on this matter, and they identified that that change would have significant one-off costs to the NI budget and have cost implications for payroll providers and potential employers, and they decided that pay provisions should mirror the provisions in GB. So it's something to keep in mind when considering the creation of that statutory payment to mitigate the impact of Section 75 discussed earlier. So that's Section 5 covered, and now Rachel's going to take over from this point. Thanks, Rachel.
Thank you. I'm going to briefly discuss the estimated costs associated with implementation of the bill. So the review of bill costs is Section 5.4 of the paper, which is on page 82 of your packs. The estimated costs are identified by the Department in the Bill's explanatory and financial memorandum at paragraphs 19 and 20. Within that, the Department has proposed 4 estimations. So there's one-off costs to the public purse of 73,000, one-off costs to businesses of 279,000, recurring costs to the public purse of 100,000, and recurring costs to businesses of 85,000. I'm only going to discuss those costs associated with the public purse. So there was no explanation detailed within the AFM for these costs. However, we contacted the department to get further information on their estimations. The department advised that the assumptions and the associated methodology underpinning the estimation of costs was based on those used in the impact assessment, which was undertaken during the GB Parental Bereavement Leave and Pay Bill process in 2018. So first of all, looking at the one-off costs, the GB impact assessment identified one-off costs of 2.1 million, and this was an estimation provided to them by HMRC, and these costs would be associated with setting up IT systems, resource costs and telephone costs. The department advised the PFSU that the 73,000 estimation in Northern Ireland is based on the assumption of an approximate 3.5% share of this GB estimation. Scrutiny points 51 to 55 on page 83 relate to this estimation. So in terms of recurring annual costs, these were estimated to be 100,000. As above, the department advised again that these costs were extrapolated from the 2018 impact assessment in GB. And that impact assessment had a number of assumptions, and I'll just go through the assumptions quickly. First of all, the number of eligible parents. So the department advised that the calculation for the number of parents was 225 child deaths per annum, and this figure was calculated using 2 data sets published by the Northern Ireland Statistics and Research Agency. The data is taken from 2018, and the 2 data sets that they use are the Northern Ireland deaths by age and stillbirth and infant death numbers So this equates to 146 deaths between the ages of 0 and 17, and then 79 stillbirths in 2018. At the time of writing, 2019 data is available, and just for comparison's sake, that equates to 215 child deaths per annum. However, the estimate assumes that there are 2 parents or legal guardians for each child who dies, and the estimate accounts for the less traditional family setup where biological parents or adoptive parent child can be separated and have new partners. So the GP impact assessment uses data from 2012, published by the Department of Work and Pensions, and it states that 1/3 of children in the UK lived in a separated family. The estimate therefore assumes that approximately 1/3 of parents experiencing a child bereavement may be separated, and the estimate also assumes that all of these parents have a new partner. The impact assessment does state or does acknowledge that this is a high estimation, but that's the estimation that they have gone with, that 100% of separated parents will have a new partner within the child's life. Scrutiny points 56 and 57 on page 85 of your packs relate to this assumption. The next thing to consider is the employment status of parents, because this has an impact on if they're eligible to make a claim. So the impact assessment for GB legislation uses data on employment rate, the self-employment rate, and the duration of employment to estimate the number of eligible parents. And this is data from the Office of National Statistics, and it's UK-based data. Scrutiny points 58 and 59 on page 86 of your pack deal with this assumption. The next assumption is relating to take-up. So the department have advised us that they've assumed a take-up rate of 87.5%, and this is based on the GB take-up rate. And scrutiny points 60 to 64 relate to this assumption. Orla discussed the Northern Ireland Parity Principle in section 5.3 of the paper. The EFM states that there was consideration given to the option of making parental bereavement pay a day one right rather than requiring a 26-week qualifying period of employment. And it further states that it consulted with HMRC and that whilst it was technically possible to do this, it would have significant cost implications. And we've just done an illustration of these costs. So the EFM states that the cost implication would be around 180,000 in terms of setting up IT systems and on a one-off cost. But it should be noted that the GB impact assessment assumed that 9% of employees would have insufficient employment tenure to qualify for parental bereavement pay. So we are now assuming that every employed parent qualifies for parental bereavement pay. And we put together an illustration on page 88 of your packs, and it just shows that if all of these parents were to take if all of these parents earned enough per week to hit the £150 threshold, then an additional 36 parents would be eligible for payments, and this would be around a cost of 11,000. So this is disproportionate to the cost of 180,000 that it would cost for HMRC to set up all the systems. There was a suggestion made that these parents could use the Department for Communities existing support scheme, and there's scrutiny points relating to this, scrutiny points 65 to 69 on page 89 of your packs. Thank you.
Not frozen.
Okay, thank you for that. That is your presentation complete yet?
Yes, Chair, yes, we're ready to take questions now.
That's great, thank you. Can I just, I suppose, start where you finished, Rachel, just in relation to the costs, and actually just where the very point that you finished in relation to the 180,000 that they would say that it would take to set up the systems to make it a day one right. Is that in addition to the 73,000 one-off cost to the public purse that was being set out to set the system up just in general?
Yeah, the 73,000 relates to, well, that cost has actually already been taken up. You know, that was set up in 2018 for the original GB version, but it's open to Northern Ireland. But to make modifications to that for Northern Ireland to have a different start date would cost an additional 180,000.
And is there, did they set out a rationale as to why that is the case?
No, that figure came directly from HMRC.
Okay.
So we don't actually have any detail on that.
Okay. No, that's useful to be aware of. I guess that is one of the main things, I suppose, that has been highlighted to us as the committee in our consultation responses and in other engagements that we have done is the issue of making it a day one right, so that people don't have to have the 26-week qualifying period. So that's something, I suppose, that we will want to take up in greater detail with the department. And some very interesting points raised as well by Orla around the I guess the Section 75 implications, some of the things that may not be completely obvious in the first instance, particularly in relation to the religious observations. So again, that's something that we will want to look at in a bit more detail. I have just Mike wanting to come in, so.
All right, Chair, thank you all for the presentation. Two points from me. You note that miscarriage is included in the legislation in New Zealand. Are there any other jurisdictions where miscarriage is included?
If I could take that one, Chair. Not that our research showed up. The New Zealand one, as you can see from the paper, is quite new, quite up to date. There was some references in the research that we looked at to do with certain states in India, but unfortunately the sources for that weren't really available. A lot of them weren't in English, and they proved quite difficult to get hold of. But in terms of that, our research showed up that yes, that was the only cases we could find. Now, we could certainly come back to the committee on that and do some more digging. But up to the point of the paper, that was New Zealand was the only jurisdiction that did show an element, a provision, if you like, for miscarriage in the legislation.
Okay, that's useful. Thank you. And the other point is, I think one respondent to the survey was the Coalition of Bereaved Workers, who of course want a scheme for workers who have lost a close relative or a partner. Is there any research into the implications of such a scheme?
No, again, I think in section 4 of the paper, we use the OECD Family Database Survey to look at statutory provision for working parents across OECD countries, and that does show up quite positive, if you like, recommendations for different countries, as I alluded to in my presentation. A lot of them do provide statutory benefits for the care of non-family members, which is quite forward thinking when we think of the traditional family changes over the years. But in terms of that specific element, no, the paper doesn't cover that. Again, that's something that we could certainly come back to the committee with.
Yeah, and just on that theme, and there was a mention, of course, of human rights in Article 8. This is maybe one for the lawyers rather than yourself, but do you think there's a possibility that the Coalition of Bereaved Workers could take some sort of case against a parental bill, in that it favours one group over another?
Could I pass that over to Orla, please?
From my legal knowledge, I would think that they wouldn't, and they wouldn't have legal grounds for that, because it's a specific bill that's tackling the issue of parental bereavement leave and pay. But it's something that they could use as a lobbying tool, I suppose, going forward to expand the rights that have been acknowledged within this bill.
Okay, that's useful. Thank you very much indeed. Thank you, Chair.
Mike? Keith?
Yeah, thank you, Chair. Just a question. I think maybe Rachel, you touched on it. regarding one-off costs for government. The one-off costs for business referred to here as familiarisation at 279,000. What is that? Can you give me a wee bit of a breakdown of what that is? Familiarisation, and where is those costs incurred within business, and how did you come up with that, or how is that figure calculated?
We actually don't look at costs for business. We just look at the public purse and the cost to the public purse. I believe that was also based on the GB impact assessment, but I don't have any further details on that.
Okay, so fair enough. Okay, that's all I wanted to ask. Thank you.
Okay, thanks, Keith. And you see, just in relation to the additional 11,000 to make it a day one, right? That's the recurring cost to the public purse.
Yes, that would be literally based on the estimation that we've used, an additional 36 parents eligible for the payment each year, just because in Northern Ireland there is quite a low number of deaths per year. So if we look at 9% of the deaths, there would be an additional 36 parents eligible for the payment, so that would be a recurring cost.
Just in relation to getting the information about the cost of businesses, Peter, how we
Chair, if you see in the paper there are a number of scrutiny points, the plan would be, with members' approval, to refer those to the department.
Okay.
To get any further detail they have. The research team have highlighted that a number of variables, if you like, have been plugged in using DWP data or HMRC data, which isn't necessarily up to date. So it's really a case of trying to find out where the department has arrived at its conclusions from. So the scrutiny points will help us do that. So when we get those back, we can go through those, and hopefully where there are gaps in the data, we can ask for further information. But that should show up the department's methodology, or where they've got their figures from.
Okay. Can we bring Sinead into the spotlight, please, Tommy?
Thank you very much for the briefing and the update. I dropped out for a moment or two there, so I really want probably Orla to go over a couple of things for me, so just that I'm clear, and it's regarding the parity across the UK and the implications of us taking a different direction in relation to a day one right. What impact could this have on the block grant? And if she could just explain that a little bit more to me, thanks.
Yeah, I think that's more a financial question that Rachel would be able to answer for you. I wouldn't have the details, the specifics. So Rachel, would you mind answering that?
Yeah, sure. That's in the very last section of the paper, and there's a couple of scrutiny points related to it as well. Basically, HMRC put together an estimated cost of basically updates to their systems, telephone costs and resource costs to change the system. The current system includes Northern Ireland, but if we were to have a slightly modified system, it would cost 180,000 to just get that off the ground and change forms and change IT systems. We put together an illustration, which I just talked about, but perhaps you dropped off, of the actual estimated recurring cost per year to Northern Ireland, and that was found to be quite low. It was only 11,000 per year, so it would take a number of years in order to sort of take back that 180,000 cost of initially setting it up.
Yeah, I thought those were the figures. As I say, I did drop out, and they're not gigantic figures. I suppose in the Economic Committee we often deal in millions when we're talking about things. When we're talking about, for example, the High Street voucher, we're spending 149 million on it. So £11,000 recurring costs to help support parents at the most distressing moment in their entire lives is not an awful lot of money, or the £180,000 as well for it to be a day one right. It's not out of any I think at all. So it really is. It's up to the committee, obviously, to scrutinise all of the issues that you've raised today. But thank you very much for the details.
Okay, thanks, Sinead. I don't have anybody else.
Chair, could I just add something to that, please? Through the chair, in terms of the macro public finance picture as well. The issue of diverging and offering more enhanced payments, if you like, to Northern Ireland recipients than GB would have a block grant and a public finance consequence. As Rachel, sorry, excuse me, as Orla mentioned in her discussion parity, in fact, if we do have a day one right, that will break parity in certain circumstances. So that those negotiations, there are scrutiny points in the paper about that, and negotiations with Treasury would have to happen to ensure that our AME payments, because Social Security payments would be an AME payment or non-annually managed expenditure. And but again, those probably are questions more for the Department for Finance to work through, as opposed to the Department for the Economy, perhaps.
John, and then
I fully appreciate the fact that all these things have to be worked through and investigated. But experience tells me that the usual answer from Treasury is no, and the usual answer from HMRC is no, we can't do that. So it does need further explored and further examined. The costs thus far don't seem to be crippling, certainly. And as has been said, if we can assist more bereaved parents, then we should explore every option to do that. That's it.
Peter?
Yeah, I suppose just to tease out, and again, this might be through the exploration, certainly on the face of it, the figures that have been suggested in terms of the difference between what would be there if we simply adopt the GB model and compared to if we have a situation where there's the day one entitlement. I suppose we'll need to just wait and see just what... is there any indication in terms of any other, and again, maybe this is an unfair question for the researchers, in terms of if, for instance, we were to agree simply to extend this to day one and beyond, obviously this has particular implications for this particular circumstance, would this have any potential knock-on implications for any level of entitlements, or at least leave an opportunity for pressing for other entitlements if this was adopted in this case compared maybe other forms of potential benefit or entitlements that would improve because at the moment there's a sort of the barrier requirement of 26 weeks?
I think that's a very good question, but I think perhaps that could be directed to the Department for Communities officials. I don't think we did not cover that area in the paper. That went beyond the scope of the actual paper. But I think that question would be better put to the officials in the Department for the Communities, perhaps.
Okay, I mean, I know we're doing various sort of lines of inquiry and finding out. I suppose the issue is there's a different. I suppose there may also be a different implication if we're in a situation where, for example, ongoing costs would mean an extra £11,000 per year, which I think anybody would say is fairly insignificant in relation to that. But if that then has no implications elsewhere, it's maybe a different situation from saying, well, because of this, it will be door open that it'll cost an extra, 5 million a year in such and such areas. So I suppose maybe just again trying to tease out where things are in terms of the position.
Okay, I don't have any other members wanting to come in for questions, so thanks very much for the briefing. It was really useful, and hopefully if we have any questions you'll be able to come back to us at some later date.
Surely. Thank you very much.
Thank you.
Thank you.
Okay, Peter, do we need to follow up on anything from that?
Chair, I have a number of notes I have made, a lot of which will be gathered up in the scrutiny points. So as members can see on the paper itself very helpfully, they have included a number of scrutiny points to seek clarification and detail and so on from the department, but also as Michael, Orla and Rachel have flagged up, Department for Finance and also Department for Communities. So what I would suggest, if members are agreeable, we will take those scrutiny points and separate them out, those that are appropriate for DFE, those that would be DOF and those that will be DFC, and forward those on to those departments for answer. The other thing probably I should flag up, and members will maybe just want to keep in the back of their minds, is the timescale for the bill. In pursuing differences or extension or widening out the bill, we come up against the issue of time. The bill is a focused bill, and it's been described generally as a foundation bill, if you like, where it gets that right on the statute book, and then that right can be built on. If we were at a different point in the mandate, there would be time for us to have taken a much longer committee stage to explore a number of other avenues. We don't have that much time, and the department has indicated that to create operational circumstances for this bill, it needs to have got to Royal Assent by the end of this year so that they can bring forward secondary legislation that will cause the operation of the benefits to flow, and that will happen in the first 3 months of next year before the end of the mandate. So that's the caution that I would have. What we can do in terms of the bill report, and hopefully that's what the information gathering we'll do will give us, is a number of recommendations. It's not unusual for a committee to make recommendations in a bill report that go beyond the scope of the bill itself. Members will have been involved in that in other committees where there are issues that members would like to be pursued that aren't within scope or aren't even necessarily the same department. Those will go as recommendations and then can be picked up, particularly as we're coming to an end of a mandate, by the successor committee, and successor minister, and so on. So I just want to have members bear that in mind. We'll gather the information and it'll allow recommendations to be made. But the position we're in terms of timeline is really tricky to get what we need to do done so that this piece of foundation legislation makes it all the way through and can be enacted before the end of the mandate. If that makes sense.
Absolutely.
But if members are in agreement, we will take the scrutiny points and we will share them out around the appropriate departments.
Peter, we don't have our witnesses for our
We
next
don't,
briefing.
Chair. So what we do is, if you want to go to matters arising, we start doing that. They're booked for 11, and it's very rare for us to finish so promptly. So we generally say, yeah, you'll be fine for 11. So if we move on to the matters arising, Chair, we'll go through those.
Okay, thank you. So item number 6 then, 6.1 at page 106 of your pack, there is a copy of correspondence from the Economy Minister to SIA outlining key decisions regarding the delivery, assessment and awarding of vocational qualifications for this academic year now. The Minister refers to the full return to face-to-face teaching for all students in the new academic year and as normal an academic learning environment as possible. The Minister also expresses the expectation that vocational exams and other assessments will go ahead in line with normal arrangements in 2021-22 as they are the fairest form of assessment for learners. So are members content to note?
Chair, potentially the caveat to add to that is that makes the assumption of an upward trajectory in progress in dealing with COVID. It doesn't necessarily take into account that further mitigating factors may have to come in along the way. Chair,
It might be useful to ask, in fact, it is useful to ask, do they have a plan B or plan C and a plan D for the scenarios that are likely to arise?
Chair, we
Plan A star.
clarify.
You can plan A star.
Well, I assume that is plan A.
Chair, can I just come in there?
Yeah, go ahead, Sinead.
Yeah, I mean, the beginning of the academic year has been anything but smooth. It's been fraught with difficulties, and we're hoping that things settle down, but there's no guarantee. So I would concur with what John has said. We welcome the letter and note it, but there's a lot of work to be done in order to actually deliver the intention of it.
Thank you. So moving on then to 6.2, at page 109 of your pack, there's a departmental response to the committee's queries regarding Piece 4, funding for Include Youth. The committee asked what interim funding arrangements will be before the new funding arrangements are in place, and the department advises that the Piece for Youth programme was funded for a finite period. If members just want to make sure that they're on mute. For a finite period, and DFE do not currently have a funding stream that could extend the current programme or provide bridge funding in advance of the proposed Peace Plus programme, and the position will be kept under review. The response also refers to the essential skills queries that Include Youth has been highlighting to us for a number of months, and The Minister has suggested that Include Youth meet with the FE sector to explore how they can meet their needs. Peter, have you had any further contact with Include Youth?
No, they haven't come back to me on any outcomes there, Chair. As you know, we've had direct contact from Include Youth about how this has progressed. Members will recall that the new reforms of youth training have brought much more into the FE colleges. However, the FE colleges will still be working with partners to apply local solutions, particularly around essential skills, which is generally based within local communities. So that's the discussion that's referred to in the letter. But if members are content, what I'll do is I'll contact Include Youth to see if those meetings are progressing and what's coming out of it. The committee may need to write again to remind the department that it's agreed to take those meetings.
Yeah, and I think the particular issue being highlighted by Include Youth was that the flexibility that is required in the delivery of those programmes is really important to the cohort of young people that they work with. And both education and health had come back to them willing to talk to them about how they might fund those programmes going forward, but economy hadn't been quite so willing to participate in those conversations. So I think perhaps it is one that we need to follow up with the department on again.
We will, Chair, and we see where that sits at the minute.
Okay, thank you. So 6.3 then, at page 111 of your pack, there's a departmental response regarding changes to the Mazen cap. The department have highlighted that they will maintain the 2020-21 increase in Mazen with the additional 410 places allocated last year, which were 192 to Queen's and 218 to Ulster, continuing to be funded for a further 2 academic years at a cost of around 2.3 million per academic year. So that's for members to note. So then moving on to 6.4, page 114, there's a departmental response regarding the SL1, the Corporate Insolvency and Governance Act 2020 Amendment of Relevant Period in Schedule 8 Number 2 regulations. The committee asked how long it is anticipated that the regulations will continue to be made, and the department have advised that the above regulations apply until the 30th of March 2022. Schedule 8 contains temporary rules which set out the process for administering the moratorium. DFE officials are currently drafting permanent rules to replace the temporary provisions contained in Schedule 8 and are liaising with the Department of Justice officials who will be responsible for taking the rules through assembly procedures. It's hoped that the permanent rules can be made and brought into operation before the end of March. So that's just for members to note, and I'm sure we'll get more information in due course.
Chair, the department had intended to legislate this year, well, last year, but the COVID impact meant that these new temporary legislation had to be brought through, so it's really just kind of turning that into something permanent. So I think it was always going to happen, it's just COVID has really driven a coach and horses through the process.
Okay, so then page 117 of your pack, there's a departmental briefing paper on how the department is implementing the review of financial process. The department states that it faces a number of challenges due to the high number of NDPBs. However, good progress has been made and a first dry run was completed on time in 2018-19, and a high-level review by the Audit Office was positive and recommendations have been implemented. So that's for members to note at this point. And then page 121 of your pack, there's a departmental briefing paper on the final outturn 2021-22. The outturn is within the permitted 99% to 100% range. So again, that is for members to note. And then just moving on to page 124 of your pack, there's correspondence from the DALO regarding free trade agreements. The DALO highlights that in summary, there remain considerable complexities around how the North will fully benefit from the FTAs included in the agreement with Iceland, Liechtenstein and Norway due to the protocol. In particular, as we move into implementation, the British Government will need to consider impacts on transparency around WTO notifications and potential trade disputes, risks arising from the inability to fully comply with FTA measures for the North, where these conflict with measures in the protocol. Moving on then to page 127. There is a copy of a Welsh legislative consent memorandum under the Minister for Education in Wales regarding the Professional Qualifications Bill. This bill will end the interim system of professional qualification that derives from the UK's membership of the EU and create a framework for the recognition of professional qualifications and experience from overseas by professions in the UK or a part of the UK to meet the needs and demands for the services provided by those professions. The Welsh Government has a number of concerns and is not recommending legislative consent for the bill, stating the Welsh Government is not opposed to the principle of recognising international qualifications and experience gained overseas, but considers the concurrent powers contained in the bill undermine the long-established powers of the Senate and the Welsh Ministers to regulate in relation to matters within devolved competence. The committee will return to this if there is any indication that the department intends to lay an ALCM, but I don't believe we've had any indications so far.
We're just not sure. That's probably likely to be winging its way towards the executive. The minister will seek executive approval.
When was that bill? Westminster?
I cannot tell you off the top of my head, but hang on. It was laid in the Lords on the 12th of May 2021. So it'll take a few months to proceed through both stages because it was laid in the Lords. It still has to go through the Commons process as well. So there's not a mad rush yet, but the issue will arise. If the Minister chooses to go along, if there's no issues raised, then effectively it will remove. Our situation here again, as per what the DALA had written about in the FTA, is slightly different because we do have still a level of EU regulation as part of the single market. So I think that's still being worked out for us. Again, this is another area that interfaces with the protocol. So there are probably very, very clever people somewhere working out exactly how that's going to work for us. We haven't had any answers on it yet. And I think that's probably why we've not had correspondence. It's still being worked out as to just really how this will work for us.
Okay. There's only one more item of matters arising, so we'll do it, and then we'll go to our witnesses. So 6.9 then at page 135, there's a response from the Competitions and Markets Authority regarding shipping costs for businesses importing to the north. The CMA advises that it has recently met with the Department for Transport and the Department for International Trade about shipping and maritime issues and are arranging to discuss the same with our international counterpart competition authorities. This includes the Competition and Consumer Protection Commission in the South, who they have contacted with a view to sharing appropriate information and ensuring that they are all alive to concerns that may or may not be specific to consumers across the island of Ireland. Obviously, members will be well aware of the huge increase in costs of shipping over the past number of months, so it's one that we can return to when we get more information. Okay, so we are now going to go back to item number 5 because our witnesses have joined us, and I'd like to welcome to this afternoon, no, we're still morning's meeting, Craig Harrison, who is Policy and Public Affairs Manager of Marie Curie, Marek Zemanek, who is Senior Public Policy Advisor of CIPD, and Bernadine McCrory, who is Country Director of Alzheimer's Society NI. So I'm going to hand over to yourselves to make an opening statement, and then we will invite members to ask questions.
Thank you very much. Chair, can I just check that you can hear me okay before
Yes.
Great. Thank you. Good morning, members. My name's Craig Harrison, and on behalf of the Coalition for Bereaved Workers, I just wanted to thank you for giving us the opportunity to present evidence to the committee today on such an important issue. The Coalition for Bereaved Workers is a campaigning group of charities, professional bodies and trade union representatives, and we exist to advocate for statutory paid bereavement leave for everyone who's bereaved of a close relative or partner in Northern Ireland. So our membership consists of Marie Curie, which is my own organisation, Action Mental Health, the Alzheimer's Society, Carers NI, CIPD, which is the Chartered Institute of Personnel and Development, Cruise Bereavement Care, NIPSA, and the Irish Congress of Trade Unions. So together we bring quite a diverse range of voices and experiences to these issues. As individual organisations, we may come at some of the more nuanced points within the bill from slightly different perspectives, but we also have a wider collective position, and I'd just like to take a few minutes to set that out for you. And we would then, of course, be happy to take any questions that members may have. The Coalition is supportive of the principles behind the Parental Bereavement Leave and Pay Bill. We think the bill is an important step towards fixing Northern Ireland's outdated system of legal protections for bereaved workers, and when it becomes law, it will make a big difference for people in Northern Ireland who find themselves in the devastating position of having lost a child aged under 18. Now, at the same time, and while we absolutely by no means sit in opposition to this bill, we also think it's a missed opportunity and runs the risk of creating a hierarchy of bereavement that will leave the majority of local bereaved people without the support they need. So just to turn to some of the detail, and beginning with Clause 1, thankfully, data from NISRA shows that only around 1% of deaths here are among people aged under 18. Now that is a great thing, of course, which is to be welcomed, but what it means is that the overwhelming majority of deaths, and I suppose by extension, the overwhelming majority of the bereaved people left behind, including bereaved parents, are not covered by the Parental Bereavement Leave and Pay Bill. It's estimated that around 1 in 10 workers are impacted by a bereavement at any one time, and those who aren't covered by this bill will continue to face a severely uneven playing field when it comes to accessing paid bereavement leave from work. You know, decisions on whether they're given time off to grieve and whether that is paid will continue to be at the discretion of their employers. And while there certainly are many great employers out there who have really compassionate bereavement policies for their staff, that unfortunately is not universal. So for example, in a CIPD survey of working adults in Northern Ireland, just 44% said that paid bereavement leave was available to them. In June of this year, Marie Curie also carried out a survey of full and part-time employees in Northern Ireland who had been bereaved during the preceding 12 months. And in that survey, 54% said that after the bereavement, they had to return to work before they were ready because they couldn't afford to stay off. And 47% worried that taking time off for the bereavement would affect their job security. Now, this survey data reinforces the stories and experiences of many bereaved employees and workers that have been shared with our coalition. Earlier this year, we put out our own call for evidence to thousands of people across Northern Ireland about their experiences of bereavement and work. And some of the testimony we got back was truly shocking. You know, people described being put under pressure by their employers to return to work almost immediately after the death, and in some cases, that was just 1 or 2 days later. Others told us that they were forced to take sick leave just to attend the funeral or the wake. And I suppose in the worst cases, people told us that they weren't offered any paid time away at all, which forced them to make a decision between either taking the time off that they needed to grieve or the risk of falling into debt. Now, in examples like this, the impact on someone's health and well-being is massive. You know, losing a loved one, whether that's a child or under 18 or someone else, is a really debilitating experience, you know, and it has a big impact on our physical and mental well-being. And that's only made all the worse if our grieving is disrupted and we aren't given the time and the space and the financial security that we need to begin processing the loss away from work. You know, what that does is make it so much more difficult to come to terms with the death and manage the impact of our grief. And the effects of that aren't just felt in the weeks and months after the death, but potentially years later. You know, anyone who's ever lost a loved one will know that there's a long list of practicalities and tasks that need to be addressed after the death, and not least, I suppose, arranging a funeral. But even things like that can be a major challenge if someone isn't given sufficient time away from work to do them. And I suppose we should also remember that many people experience bereavement, including the bereavement of a child, potentially following a period where they were unwell. And in that situation, the employee might have provided care to them, and as we know that so many carers do, they may have had to use annual leave or unpaid time off to accommodate that caring role. So when their loved one dies and they're likely to be physically and emotionally exhausted, they may not have any avenues available to them to take time away from work and begin coming to terms with that loss. And that really is an unacceptable position for anyone to find themselves in. The stories I've been describing are the reality facing many bereaved employees in Northern Ireland today. And while our coalition certainly is pleased that this bill will help to ensure that that sort of thing doesn't continue to happen to some bereaved parents, we are very concerned that the playing field is going to continue to be so uneven for everyone who falls outside of it. You know, as I said at the start, the goal of the Coalition for Bereaved Workers is to see the introduction of 2 weeks statutory bereavement leave and pay for everyone who's bereaved of a close relative or partner in Northern Ireland. And we think that would really help to level the playing field and ensure that more workers and employees receive the support they need when they lose a loved one. Now, while we recognise that delivering that isn't possible in totality within the scope of this bill, we would plead with members and with the department to consider stretching that scope as far as possible so that as many bereaved workers as possible can benefit from the support the bill provides. So, for example, extending the bill so that it covers so that it covers parents bereaved of a child beyond the age of 18 won't fix this for a lot of people, but it will make a difference for some. And considering how relatively modest the cost of the legislation is expected to be, such an extension would seem to be affordable to the executive. Now, any such extension would still be required to adhere to the same T's and C's that are currently within the bill. So I'd like to concentrate on some of those details now. You know, we know that everyone's experience of loss is different, so it's impossible to legislate for the amount of time that different people will need away from work to begin that grieving process. But that being said, a statutory right to 2 weeks off is a good start, and so we're supportive of that provision. You know, I mentioned earlier the evidence that many bereaved people are offered little or no time off at all, so 2 weeks is a big improvement on that. Being able to take the leave within a 56-week period of the death, which I think has been suggested by some members and perhaps the Minister during earlier stages of the parliamentary process, that's another sort of approach that we support, and it's actually more closely aligned with the clinical evidence of grief. You know, there once was a dominant theory that grief is experienced in, I suppose, sequential stages. But that's been largely disproven, and we know that for the majority of people, you know, grief is an individual, non-linear experience. So the 56 weeks reflects that, and I think importantly, it would allow for important reminder events like birthdays and anniversaries to be covered within the bill. Just to move on to clause 2 regarding the value of bereavement leave payments, you know, we are supportive of the approach that's been taken elsewhere in terms of around £150 or 90% of someone's average wage. You know, many of the bereaved people we'd engage with had to go off on unpaid leave or sick leave to get the time away from work that they needed. And the value of bereavement payments certainly compares quite favourably to the likes of statutory sick pay, you know, which members will be well aware isn't very generous by global standards within the UK. You know, we know that being plunged into a precarious financial position because of insufficient leave after a bereavement only compounds the impact of a loss. So those payments will make an important difference. Now, at the same time, we would certainly be supportive of the bereavement payments being more closely earnings related, and we also think that consideration should be given to making those payments a day one right, you know, so that as many employees and as many workers as possible can benefit from the support they provide. You know, the impact of grief and the impact it has on someone doesn't change based on how many days or weeks they've been in a job, so it doesn't seem fair to exclude people from the policy on that basis. So just in summary, the Coalition for Bereaved Workers supports the principles of this bill, but we believe the department needs to go further. You know, we need to level the playing field for bereaved workers in Northern Ireland and use the powers devolved to Stormont to deliver a much more ambitious system of legal protections for them, whether the person they lost is a child aged under 18 or a child aged over 18 or someone else. And I'd just like to finish quickly by reading out testimony from Lucy, who's a worker in Northern Ireland and lost a close loved one while in employment. And I think her story really underlines why we need to do more. So she said, "My relative died on a Sunday. I was back in work on Wednesday morning. I couldn't afford to stay off work and wasn't paid for the 2 days I had to take. It absolutely affected my ability to grieve. I was completely bereft, exhausted and shell-shocked. Having to worry about money at such a harrowing time is a very real issue. You have no time to grieve. Putting workers in that unpaid position is simply cruel. That is what the uneven playing field looks like for some bereaved people in Northern Ireland today. And I'm sure members would agree that that sort of experience just shouldn't be tolerated. And that's why we need to go further than what is being proposed at this stage by this bill, and perhaps starting with some of the issues that I outlined earlier. So thank you again very much for your time. And as I said, would be happy to take any questions that members may have.
Thanks very much, Craig. And I think that I certainly find the statistics and the feedback that you laid out in your survey and in your paper quite stark and quite harrowing. I think we all recognise the impact that bereavement has on workers and the lack of protection that is there for many of them. And as you say, of course, there are examples of good employers, but there are also examples, as you've just highlighted, of where there is not good protections for workers. And of course, it's entirely counterproductive to force someone back into the workplace very quickly after a bereavement and potentially defer the impact on particularly their mental health to a later date, and they would perhaps then need to take sick leave at some point in the near future. And of course, as you have highlighted, the practicalities as well around dealing with a bereavement, and I suppose here often funerals happen very shortly after bereavement, but if someone dies, for example, in England, that can be the case where a funeral is a couple of weeks or even a couple of months down the line. So it's important that there is that ability for people to take leave, certainly, and absolutely to have a statutory minimum of an entitlement to pay. You've made the points, I think, very well in respect of the bill that is proceeding at the minute, and as I know you're aware from having met with you previously, that obviously that is a copy and paste of legislation that was put in place in Britain, and I guess for us it is a minimum that we can work from, and certainly this is an issue that I think that as a committee that we will want to look at in more detail in the very near future. Obviously, we don't want to delay the proceeding of this bill through its processes and to get it completed before the end of the mandate, but certainly the issues that you have highlighted are ones that we very much think that would need to be taken on board and to be dealt with for workers. So, Mike, you have a question you wanted to put to the
Chair? Yeah, thank you very much. And I should declare I've already had a session with the Coalition of Bereaved Workers, including Bernadine and Craig. And I think instinctively, Craig, I'm sympathetic to the logic of the argument. But what I want to ask you about is whether you feel you should be making your case on its own merits, or whether you're to a certain extent trying to attach it to the Parental Bereavement Bill. Some years ago on another committee, we were legislating for the Historical Institutional Abuse Inquiry. And some of us were unhappy with the scope because it only included abuse that took place in institutions rather than domestic and other settings. But the advice we were given was if you want to do that and broaden the scope of the bill, everything pauses, and it could take a very long time to get the bill over the line. And given the age profile of the victims and survivors, people would die without getting recourse to that channel of information and justice. And given where we are in this mandate, if we were to pause to try and expand the Parental Bereavement Bill into a Bereaved Workers Bill, I doubt very much whether we might get that over the line between the end of the mandate. So where are you on that position?
I think I absolutely agree with you 100%. And just to be, I suppose, totally 100% clear about it, we absolutely do not oppose this bill or want to see it paused or stopped, not in any way, shape or form. It is going to make a big difference to bring in what is a really outdated system of legal protections, I suppose, into, bringing them much more up to date. Our point of view on this is that as you said, there's a short amount of time to get this through during this mandate, so it's important to concentrate on those bits that maybe can be changed at this stage, so that it, as the clerk said earlier, if this is going to be a foundational piece of legislation to be built on later, we need to make sure the foundation is as robust and strong as possible. So that's why we certainly don't want to see it paused or advocating at this stage that it be extended to a wider group. But certainly within the scope of the bill, it would seem that there are opportunities to make it that bit better so that we get off to a good start for what comes later. And I suppose I'm thinking particularly about the likes of day one rights within that context, because if this becomes a day one right for bereaved parents, it's much easier to make it a day one right for wider groups that need it, in subsequent mandates.
I think that's very reasonable. Thank you very much, Craig. Thanks, Chair.
Mike. Sinead, can we bring Sinead into the spotlight, please, Tommy?
Thank you very much for your presentation, and I too have met with the group previously, and I know that the legislation doesn't meet I suppose the aspiration of your group, and it doesn't cover it in the scope of the current legislation. And I do understand that you're not seeking to kind of pause this in order to drive the aims of the coalition forward. But it is very important, because this legislation will be a precedent, will set that precedence of that day one right, and it's so important. And I think it's great that we have the CIPD as part of this coalition, because one of the issues that really sometimes goes under the radar, we keep on talking, how much is this going to cost, how can we afford to pay for this? Will that drive down money from our block grant, etc., etc.? And some of the focus should be actually, how much is this costing us not to do it? I recently spoke to, I was doing an interview one day with a journalist, and the journalist had moved on to another employer, and the reason she had moved on is because how they treated her when she lost her parent. Because if you're not treated properly, with dignity and with compassion, then you lose your loyalty to that employer. And it never comes back, actually, because at that moment of most need, they weren't there for you, and all your skills and all your richness and that leaves with you as well. And employers are sometimes short-sighted in giving leave at a time of bereavement. So I think that your position has been well put. And it's something that we as a committee need to think about in terms of scrutiny, because the work that we do on this parental bereavement leave will impact on the wider ambition to have legal protections for all employees as a day one right. And I think that we need to take cognizance of that. I've been in that position. I have been that employee as well, caring for a parent, just finding going back to work just nearly impossible. Grieving is a process, but everybody processes it individually. And it's what you might think, God, they're coping really, really well very shortly after bereavement, can just fall apart very, very, very quickly. And it's something that we should protect legally, all of our employees. Thank you.
Okay, Craig, just a quick question there. You referred in here in your document that paid bereavement leave is not universal. Is there any sector or business paying the 2 weeks that you're aware of? Obviously, you don't need to know them individually, but is there a percentage of them doing that? And what is the average across business? Is it 2 days, 3 days, 4 days? Have you any idea of that?
It might be a good opportunity to bring Marika in just to touch on that, because I think the CIPD survey that I mentioned earlier did look at a high level at I think, public versus private sector. So he might have some insights to share with you on that.
Thank you, Craig. I hope everybody can hear me okay. Yes, the survey that Craig mentioned, just to give a bit of background, is a survey of 1,000 working adults in Northern Ireland that YouGov ran for us. It's a very broad sort of job quality survey that looks at many different dimensions of job quality, but the availability of employee benefits is one of them. Now, we asked, because we were part of the Coalition for Bereaved Workers, we asked a specific question about the availability of paid bereavement leave. And as Craig mentioned, we found that about 44% of employees in Northern Ireland had paid bereavement leave available to them. You got about 15% who simply don't know, and about 40% who said that this is not available to them. Now, when it comes to sort of differences by sector or industry, the sample is strong enough to allow for some high-level analysis. It doesn't allow us to drill down into differences by industry, for example, but we can see very clearly that there's a difference between public sector and private sector employees. So we had 55% of public sector employees say that this is available to them, compared to only 40% of private sector employees. Now, this is largely as a result of organizational size, because there's a very, very big difference by employees working for different sized organizations. As you would expect, employees who work for the smallest businesses, so for businesses which have 49 employees, only about 2% of those employees have paid bereavement leave available, which rises to 40% for those working for medium-sized businesses, and then to 59% working for large businesses. Now, that's the extent that we can use the data. We don't have any other numbers, I'm afraid, on sort of average length that is being provided across Northern Ireland, but this is probably the closest we can get to getting an idea of what the differences are between different employees.
Okay, thank you. Thanks, Chair.
Thank you. Okay. I don't have any other members wanting to come in for questions, and as I says at the beginning, I think that this is an issue that the committee will certainly want to reflect on in our consideration of the bill, and also any recommendations that we are making in respect of the bill for further work that needs to be looked at, as you've highlighted yourself, going into the next mandate. So we'll certainly reflect this briefing and raise the issues that you have raised with every other organisation that's coming in to talk to us about the bill.
Chair, everything will be hand-sorted, so we're able to share the evidence that we have in each session, and all of that will go into the bill report as well, along with the minutes and so on.
So thanks very much for taking the time to join us, and for coming along and giving us the information this morning.
Thank you for having us. Thank you.
Thank you.
So before the next section starts, is there any chance of getting that TV raised a bit? I'm sitting here looking into Keith's eyes.
Tommy, would you like to have a go at that?
Oh, I say.
Are you even shifted over this way a bit? Keep that one.
Should we all leave?
No, stay. Please stay.
All it is a candle. That's a bit better there, yes.
I get to look in his eyes now.
Can you see it?
It's not as good as it was, but I don't know.
What if it tilted that way a bit?
Even in between Peter and Heath, would that work?
Somebody should have been to the left, eh?
Aye, that.
I'll move, sure.
It used to be higher. It used to be a bigger screen.
What
As
do you
well.
know?
Oh, did it? Oh,
Yeah,
right.
we've only got the one bigger one on the good stand, but actually it might be better off.
Oh, that's okay. That's good. As long as you can see
okay
it.
for me. Yeah.
Everyone, yeah.
Thanks.
Stop now, because that could get a lot worse.
Okay, so moving on then to item number 7, which is the Parental Bereavement Leave and Pay Bill. There's a clerk's memo at page 138 of your pack. There is a summary of survey results from Citizen Space at page 141. There are responses from the Committees for Infrastructure and Justice to the call of evidence at page 160 and 61. A copy of the admissibility criteria for amendments to a bill at page 162, An additional bill pack was sent out yesterday evening to members electronically, which includes a copy of the written submissions received on the bill under section 10 of that pack. The committee carried out a survey consultation via Citizen Space on the Parental Bereavement Leave and Pay Bill from the 23rd of June to the 16th of August. We received 382 responses to that consultation, mainly from individuals. This is considerably more responses than what were made to the department's consultation. The committee also received separate written submissions from a number of representative bodies, and that includes NIPSA, Unison, the Women's Policy Group, NI, Women's Resource and Development Agency, the Women's Regional Consortium, the Coalition of Bereaved Workers, the Human Rights Commission and FSB. The committee has heard today from the Bereaved Workers Coalition, and it includes membership of NIPSA and ICTU. We are due to hear oral evidence from the Human Rights Commission and FSB at next week's meeting. So we're obviously very grateful to all of those who have responded to us and to have received such a high volume of responses from individuals impacted by parental bereavement, and we have formally written to thank them for taking part in the bill survey. It has obviously allowed the committee to gain an insight into how the provisions of the bill will impact in practice. The quality of information and individual views gathered through the survey will enable the committee to produce a detailed evidence-based report without the need to place any burden on individuals to give oral evidence in difficult circumstances. So if the committee is agreed, we will proceed with the oral evidence sessions as have been outlined, and I think are included in the forward work programme as well.
Chair, and we're still adding to those. We're looking at Unison coming in as well. As you've referenced, we did talk to support groups about the best way to approach this, and their advice was, if you don't have a necessity to make people relive the situations they've been in, then they would advise against that. Because we got so many individual responses who have given us contact details, what we've looked at is we've gone back and said to them, look, if we want to seek further, consideration of references or whatever, we will use you as a reference group. So we have 73 people in that group. So it means we're not, as I say, we're not kind of putting a huge burden on individuals to relive their stories. Chair, John.
Quite rightly and understandably, there's a considerable number of groups there from women's organisations who have responded. But is there a breakdown in terms of the individual responses in terms of gender? Do we need to reach out to men's groups in terms of these issues? Because men don't talk about their feelings. Bereavement affects you regardless of gender. Is that something we need to do?
Let me go back again. I'm trying to think. We'll have that breakdown from the survey. I'm trying to think back to I don't think we quantified it for the 73 individuals. Let me go back and see what we have on that. Tommy? The report will...
The names, you make a judgment of male or female, but it could be done like that.
But in terms of specific male groups, unless they're within we haven't had any individual male group. There are some in coalitions, but the vast majority of group responses we got were from groups that are mainly women's groups. So we'll take that away and actually do some direct approaches. We'll probably also talk to some of the other groups. There are a number of collectives, so we might actually be able to go back to them and try and specifically tease out some views from men's groups. Because although we've closed our call for evidence on that bigger survey, as I say, we now have these contacts we can talk to in terms of reference. So if you leave that with us, we'll come back with more details of where we can go with that. But okay. Absolutely, that's probably the most glaring gap I would think we probably have.
Is there an association of men's sheds?
There is, and that's. I'm trying to think, were they in any of the collective groups? I don't think they were, but that's a good group sort of to approach. Yeah. Yeah, we'll pin that down. I think there's a fair few we can go to, And it may simply mean letting them, have a look at the survey as well. But I think you're absolutely right. We need to make sure that there's that balance. Leave that in our hands, Chair.
Thank you. So moving on then to item number 8, and it's the SL1 on the High Street Voucher Scheme, the High Street Coronavirus Financial Assistance Scheme Regulations NI 2021. There is a clerk's memo at page 164 of your pack. The SL1 is at page 166 of your pack. There's a response from the Minister at page 171, a copy of the DFE Equality Screening document at page 173. There is a letter from the Minister regarding the launch of the High Street Stimulus Scheme at page 3 of the table papers, and a response from the Department to the Committee's most recent queries on the High Street Voucher Scheme at page 5 of table papers. The Committee had previously noted the SL1, and we had raised a number of queries which have been responded to in that document at page 171. The response from the Department advises that for the purposes of GDPR, anyone under the age of 18 is considered to be a child, and any authority processing a child's data needs to undertake child-specific considerations to ensure there is a lawful basis for processing a child's data. There may also be a need to capture the data of those who have legal responsibility. The Department has also provided screenshots of the High Street Voucher Scheme portal and has stated that cyber testing is currently scheduled to be completed in the next week. The Minister has also written to confirm the opening of applications for the High Street Voucher Scheme on the 27th of September as launched in the media yesterday. The portal will remain open for 4 weeks, and the first prepaid cards are expected to issue to people across the North in the week commencing the 4th of October. A specific digital proxy or telephone service will commence on the 11th of October for those without internet access or ability to use the digital service. The Department is currently putting in place some final details of the High Street scheme before the SR can be finalised, and is expecting to approve the SR this week before sending it to be approved by the First Ministers as required under the Financial Assistance NI Act 2009. It is currently expected that the SR will be laid on the 20th of September as per the Minister's most recent letter. The statutory rule will allow the High Street Stimulus Scheme to operate, so that rule is subject to negative resolution procedure. So this is the Committee's opportunity to consider the policy set out in the SL1, as it's not possible to amend once the rule has been made and laid in the Assembly Business Office. Members, we have previously noted the SL1. We had raised a number of queries with the Minister and the Department in respect of the policy content. We have already raised a number of concerns in respect of that, and this is the Committee's opportunity to reflect on whether it now wants to highlight support for the scheme or to continue just to note the SL1. The Committee, the SR will come to the Committee, I assume, next week?
Theoretically so. If it's laid as planned on the 20th, Chair, we'll have it in the table pack for next week. Obviously, we haven't seen any draft of that, and we're not 100% sure whether they use the old commencement date of the 12th or whether it's of the 20th. But to be honest, that's academic now. So the reason we've put it on the agenda again is because previously the members' action was to note, and as members are aware, if you want to change that action, it needs to be a case of having the item on the agenda again. So it's currently being noted by members. We've had responses from the Minister on a range of issues, particularly on the 16 and 17-year-olds, around GDPR issues, the need for a separate QIA on it. So that information's all there in the pack for members to consider. So the committee can continue to note the SL1, or can, because it's an item on the agenda, if it wishes, members can now agree to the policy direction as outlined.
I suppose just to say that it was a bit disappointing that there was the lack of clarity around the opening date of the scheme, and the lack of communication, I suppose, from the Department and the Minister last week, leading into when we were expecting, as the dates had been set out in the SL1 of the 12th of September and the 13th of September, and considerable expectation and anticipation that that's when the scheme was going to open, and we didn't actually get that clarity until yesterday. And I think that it is also disappointing that the 16 and 17-year-old are not being included in the scheme as it stands. The rationale that has been laid out in relation to the data, there are issues that could be resolved, that there are potential solutions there, and you know, this is an issue that the committee raised as far back as April, as far as I can remember, with the department. So those are issues that could have been considered in the development of the scheme. On that basis, I wouldn't be changing my position of noting the SL1 at this point.
Stuart has a query, Chair.
Go on ahead, Stuart.
Good morning, Chair. Hope you can hear me.
Can? Yeah, we can.
Good, thank you. Quick query just in relation to the telephone system that's being used. Bearing in mind that the telephone system is specifically for people who don't have internet and therefore may have other difficulties in accessing the system, can we express our disappointment that that is not going coterminous with the online application? Because the reality is that people who will be using the phone system are perhaps people who will actually need a little more time to actually work out how to spend their cards and vouchers. So I think it's important that we do express our disappointment that they're not running it alongside the online application process. And like you, Chair, I think there's disappointment that that insufficient thought was given to 16 and 17-year-olds, and at this stage we should continue just to note.
Thanks, Stuart. And yeah, the issue in relation to the opening of the online portal and the opening of the phone application process, the department has set out their rationale in the letter to us. But as Stuart has rightly pointed out, that does give those people who are only able to apply via the phone application a shorter time to use their cards. And I think it is something that we should ask the department if it can be looked at being brought forward. John, sorry.
Thank you, Chair. I have concerns about the equality impact assessment that we've been provided with. I think we were told at our meeting last week that it was completed.
The 20th of August. Yeah,
that was
this document is dated the 10th of September, which means that it was only completed 5 days ago. Best practice tells you that equality impact assessment should be carried out as part of the decision-making process, not as part of the ratification of the decision-making process. So the equality scheme should have been in place and evolving from the very first stages of this scheme being considered by the Minister's Department. And if it had have been part of the decision-making process, it would have identified the issue of 16 and 17-year-olds at a much earlier stage and have been able to provide remedies if remedies were the objective of the department. And also in relation to the point that Stuart has raised, those who cannot access digital means, most likely the elderly, most likely the disadvantaged, but also have been identified much earlier, and you wouldn't have seen the circumstances arise where they're able to now, or not even able to, they're being excluded for 2 weeks from the scheme. So there's a deep flaw in the department's equality impact assessment and processing, and I would like to know why we were told last week this was completed, but it's actually dated the 10th of September as the completion date.
Mike?
Yeah, Chair, I wonder if, as a committee, we could take a position of supporting a separate scheme for 16 and 17-year-olds to run from January, which would give the department time to iron out any technical issues over data and the rest, and would be timely for the High Street, January being pretty much a dead month.
Claire?
Sure, I agree with Mike. He and I both appeared on Spotlight last night, and it was really just to pick a point. The Finance Minister had suggested that he did believe that there was indeed money left to potentially be able to provide a 16, 17-year-old scheme, and I think at this stage it probably does make more sense to have it as a separate scheme rather than to delay the current one. I'd be keen to know, what the department is thinking of in terms of that money anyway, because I would imagine that money has to be spent by the end of this financial year. And, are they thinking along these lines, or are they looking at any other type of scheme? I know there was suggested a hospitality scheme. Is that where that money's going to go? I think that's an interesting point. In relation to the scheme too, I've had a couple of queries from constituents in relation to care homes and assisted living. So, is the department thinking of a mechanism where maybe someone who leads those organisations, rather than direct next of kin or that, be able to assist those people being able to apply for this scheme? I'm just conscious that there are some people who just don't have that, and that's why they're in some of those facilities. So, is the department sort of looking at it on an organisational basis in terms of assistance? I think that might be useful as well.
Just I suppose to say in relation to the point that Mike has raised and that Claire has raised, that was included in our letter following the meeting on the 25th of August, and the response back from the Minister was that there would be no evidence that there would be a significant contribution from 16 and 17-year-olds to our economy from extending the voucher to them, which is quite disappointing of an attitude. So, sorry, Sinead, is your next?
Yeah, well, it's just really to emphasise that I too am disappointed in the response by the Minister in relation to the 16 to 17-year-olds. If we are using this scheme to change behaviours, well, that's actually the cohort that we need to be chasing, because we want them to get into the high street, and their purchasing is rather different from those in the other age cohorts as well, which would be significant to our retailers in the high street as well. So we need to, I think we need to go back to the Minister on that. I'm uncomfortable with the equality impact assessment. Just when was it carried out? Because we were led to believe that it had already taken place way in advance, and now it seems to be a quality impact assessment that has been done in reverse of the scheme. So we need a little bit of clarity here, because that's just out of order in every aspect of Section 75 as well.
Thanks, Sinead. And just Peter's just reminded me about the pre-launch communications plan that the department had highlighted that was going to be happening. We have seen the Minister has been launching the card in various places across the north, but have heard some feedback from local businesses about there not being very clear about how the scheme is going to be practically rolled out from their perspective. So it would be useful if we could get some more information from the department just in relation to that communications plan. And obviously we have a role in terms of encouraging people to use their vouchers in their local businesses as well, and I'm sure members will take every opportunity to do that. But it would be useful maybe to even get some feedback from chambers. I'm sure there has been communication from the department to those bodies, but if we could just get some further information in respect of that.
Chair, that was something I recall officials said on the 25th of August, was that they had worked with the chambers. So what might be useful is if we can get direct information from them as to just what exactly the form of that was. Yeah, we can pursue that.
Yeah, go ahead, Peter.
Chair, thank you. I suppose on a couple of points. First of all, on the broader issue of, I think rather than trying to suggest there should be some specific scheme or whatever, I think we do need to tease out a wee bit more thinking around where spend is in terms of the under 18s, because, without getting into the arguments back and forward in terms of what's been put forward as the propositions, to my mind, I don't see an enormous amount of distinction as then if we're saying 16 to 17-year-olds potentially should be part of a different scheme. Why not 14 or 15-year-olds? Why not make the argument that actually in terms of stimulating spend, there are, in terms of a family spend, there's an awful lot of pressure often on families in terms of additional spend that they should be looking at or could be looking at if they've got young children, for instance. And so, I think we need a wee bit of a wider discussion. If there is consideration of, say, there is underspend, how do we look at a different scheme or whatever, or an additional scheme, whether, if that's to be considered, say, for 16 to 17-year-olds, whether it's actually something that needs to be looked in a wider context of what can actually be done for families, children, because I think there's more of a debate around that rather than simply come to a solution at the start of that process. I think we do need a bit of conversation. The other point I would make, but I mean, I'm not going to try and press this in terms of any vote, but I'll just express certainly my view on it. I think it's perfectly fair for people to say, and I think that's where the queries are of, what about this, what about the time gap? Let's press the department on such and such. I think it is important, while all those things are important, it is also important, I think, that we do not lose sight of the big picture in relation to this, in regards to this, and specifically therefore the SL1. We have seen, I suppose, that there is a similar position we heard last night, I think, from representatives from Jersey, where they had used this. This was a very useful tool in helping to stimulate retail. It is something which our retail sector is very keen to see happening. It will be putting important money in their pockets at a particular time of the year where we can't simply elongate this out in relation to it. Look, I don't want to create division within the committee in that regard, so I wouldn't press on people with a formal vote, for instance, on that basis. My preference would be on a personal basis. I would welcome the SL1, but I appreciate that I'm possibly judging that there may not be a mood of a majority for that, but I would very happy for that to be placed on record, that I would be supportive of the SL1, and maybe that's the way to carry it forward, rather than us getting into votes which could be 5-4 one way or the other in relation to that.
Chair, it's still, the committee has noted it, and that can simply just stand. There's no requirement to do anything other than that. The SR will come anyway, whether the committee notes, agrees or otherwise, and the committee has flagged up in terms of the purpose of the SL1, the policy outline. The committee has raised that initial set of concerns. Now that the committee has seen more detail, there are a further set of concerns around the timescale of the phone and so on that can be raised again with the department. There's no requirement for the committee to do any other action.
I understand that, to ask maybe the clerk via the chair in relation to that. I mean, on that basis, again, just in terms of the way these things are recorded, is there an opportunity at least then to record, certainly from my own point of view, the minutes that I would be supportive of SL1? I don't know if others would.
You can record anything. Should a committee decide we can record that?
Right, yeah. Just want to come in on Claire's point. I suppose I was watching that party political broadcast last night on television, and with respect to the Department of Finance, the Finance Minister referred, I think it was 300+ million or something he referred to the Department of Economy got. I can't remember the exact figure, but just on Claire's point, I'd like to support that and get clarification what that sort of aimed out at, because the indication was last night they're only going to spend 149 and there's all this money left. I don't expect that to be the case, but it'd be good to get clarity on what that 300, whatever the figure was, just to pick up on Claire's point. If you're happy enough for that, Claire.
The DFE were allocated 290 million for the Economic Recovery Action Plan and have full flexibility within that as to what they allocate it to. They have allocated 145 million to the High Street Voucher Scheme as it stands, but they do have the ability to spend the money within that envelope as within the scope of economic recovery.
Yeah. We have good to find out what they're...
Chair, we have the Minister in on the 29th to talk about that. Members are aware there are a series of planned actions within the Economic Recovery Action Plan that aren't necessarily, they haven't necessarily got a figure attached to them. So the Minister will be able to give more information on what the balance of the funding that was granted for the ERAP will do. In terms of the spend on this, because it's under COVID relief, there is that flexibility, as the Chair had indicated, and the committee has already written to the Minister to suggest that while members understand the timing of this scheme as now, the slot that has been recommended pre-Christmas, at a time when retail could benefit from this, there will be some underspend of some kind available post the scheme, so that there is an opportunity, should the department pursue that, for them to look at some further mechanism. The issue there, which we'd flagged up with the department for clarification, was the dispensation that the department's getting on this scheme in terms of tax and benefits is a one-off thing. So the clarification we'd sought I'm trying to remember what we got in response. I don't think it was clarified. Was whether a brand new scheme for 16 and 17-year-olds would be like a second go at that dispensation, or whether the scheme is one-off, and should you repeat the scheme even with different people, that's it, it's a one-off. So that was the other issue for clarification, was whether or not the £100 would actually be £100 if you ran the scheme again. So there's a lot of issues there, and in terms of the launch on the SR coming on Monday, and then the launch the following Monday. I suppose in terms of time scale, the scheme will proceed as it looks, unless there is intervention from the SR. However, we have the Minister on the 29th. We'll flag up all the issues that have been raised as part of our meeting readout for the DALO. But that also then provides an opportunity for direct engagement with the Minister on this, which I'm sure he would welcome. But it'll also allow members to probe a bit more on as Mr. Buchanan said, the thinking on what's going to happen with the rest of ERAP. Where we stand, and for just off the top of my head, for example, where we stand with who's not going to get a job from furlough. That was one of the other issues raised around the potential for retail getting a bigger spend, being able to pick up people who aren't going back to work from furlough and so on. So we'll raise all these issues, and then the Minister, as I say, will be in front of the committee and can give probably not much of an update because we'd only be a couple of days into the scheme, but he can at least comment on flows, kind of uptake, whether by that stage we know whether the system works or not. But that will at least allow members that direct engagement with the Minister.
If he's still Minister?
I couldn't possibly comment. But that's our schedule as stands. The other complication, I'll just throw that in as we're talking about that meeting, is that's our short day, but we are seeking to swap rooms, or the alternative, while not ideal, is we have unlimited time on a virtual channel, which would mean the entire meeting being virtual, but it would give us that extra time. But at the minute we're trying to swap. That's our first preference.
Is the Assembly Chamber available to committees?
It is, and we can pursue that. We're really hopeful we'll get the swap with the Senate. We've been very nice to the Committee for Infrastructure, and they're doing a strategy session, so we're hopeful that they don't need to be live and they can come in here. So we'll pursue that if necessary. We'll look at the Chamber. Failing all that, as I say, there is a new, completely virtual, open-ended channel that we could use.
Did you want to come back in, Mike?
Yeah, Chair, I don't want to prolong the debate, but Peter raises the question of why not 13, 14-year-olds or whatever. Well, the answer is it's at 16 that you get your national insurance number, so there's an inherent logic in 16 as a starting point.
It's the verification. Chair mentioned Jersey. What they did was they simply gave to all residents, which was pretty much everybody who has resident status, and that just made their lives really easy. Because of because obviously this is a bigger number of people, and the date of verification, officials helpfully described it as a lift. So if they've got your national insurance number, you can come out on the first floor because that's your data verified. So that is the thinking that the Children's Law Centre and so on has put forward for the 16 and 17-year-olds, because that data is available. It's much more complex with anyone below that. But as the department has suggested, their advice is even with the 16 and 17-year-olds, you're looking at further complications of them as minors, GDPR issues and so on. So as the scheme sits to launch in the time scale, it is 18 plus, and it will be the registration system with the data sets they have available and an appeal process. Where there is no findable data on the person if they're applying, that can be dealt with then in another fashion. We will flag up all the issues. We'll have the Minister in on the 29th, and we can put on the record that there were members who are supportive of the SL1 as drafted. So we can do all that, Chair. There is no requirement to change the action of noting.
Okay, thank you. Okay, members, moving on then to item number 9, which is the SL1, the Corporate Insolvency and Governance Act 2020 Coronavirus Amendment of Schedule 11, Regulations NI 2021. There is a clerk's memo at page 196 of your pack, and then the SL1 itself is at page 197. This statutory rule replaces Schedule 11 of the Corporate Insolvency and Governance Act 2020, the SIG Act, with a substitute which will provide for new, less stringent restrictions on creditors' right to petition to have insolvent companies wound up to apply for a 6-month period from the 1st of October 2021 to the 31st of March 2022. The rule is subject to confirmatory resolution procedure. The anticipated date that the rule will come into operation is the 1st of October. This is the committee's opportunity to consider the policy set out in the SL1, as it's not possible to amend once it has been laid in the Assembly Business Office. So are members content with the policy direction as laid out in the SL1?
Yep. Thank you.
And then moving on to the SL1, the Education Student Fees, Amounts, Loan Repayment and Support, etc. Amendment Regulations NI 2021. There is a clerk's memo at page 201 and then the SL1 itself at page 202. This statutory rule will provide for the annual increases using the inflationary forecast of 2.3% for the academic year 2022-23 provided by the Treasury to the prescribed basic and higher amounts which higher education institutions here may charge to students who are ordinarily resident in the North and accepted others. The Department provided a response to members' queries arising from the committee meeting on the 30th of June in relation to the historical background for the lack of regulation for fees on part-time courses. This response is at page 12 of table papers. The Department states that the power to make regulations comes from the Higher Education NI Order 2005. A course within the 2005 order does not include any part-time or postgraduate course other than a course of initial teacher training. The Department therefore does not have the power to set in the fees amounts regulations the amount a publicly funded higher education institution can charge for part-time or postgraduate courses. Changes to primary legislation would be required to amend the definition of a course to make provision for such a power. So that sets out the query that we had in respect of that. So this rule is subject to negative resolution procedure. The anticipated date that the rule will come into operation is the 1st of September 2022, and this is the committee's opportunity to consider the policy set out in the SL1, as it's not possible to amend once the rule has been made and laid in the Assembly Business Office. So are members content with the policy direction?
Thank you.
I don't think there's any likelihood of us being able to examine part-time student fees in this mandate, short or long as it's going to be, but nobody knows where we're going to be after the next elections. But if there was an opportunity for the committee to look at it in a new term, I think it's something that would be a useful piece of work.
Chair, we actually did a wee bit of digging, and part of the rationale behind exclusion from the original order was the sheer variety of part-time and post-grad. Trying to pin down a fee structure for that was considered probably not viable. With the course structures, it's a lot easier to say you have these parameters, particularly with post-grad. The variation in what you needed to charge for it was such that it was trying to capture it within legislation. What potentially you could look at, and again it would be for a new mandate, is setting parameters based on variables. X, Y and Z you can charge within this, A, B and C you can charge within this, which would therefore mean that there would be some structure to it. At the minute there is no structure whatsoever. Something to think about for a future mandate. We could put it in the committee's legacy report if members are willing. We can, we're already listing for that.
Yeah, and considering the issue has been raised with us in respect of part-time fees, and it's one that we have looked at, it might be.
Tommy can put that on his list.
Chair, the rate of inflation you quoted there is lower than the actual. Is that an issue for us?
Potentially, yes. The media is reflecting that the rate is currently 3.2% and they're operating on a very low 2.3%. I think the 3.2 came as a real surprise. Unfortunately, because of the nature of these, we commit really far in advance. And the hope will be that things will even out. But because we if you like, we legislate that year in advance, we're kind of on a treasury model that is not foolproof or
And I suppose
currently advantages the students.
Yes.
So,
yeah. So, yeah, and that's basically it. That's the figure that will go. So wherever inflation goes,
The
they're
problem
based on the
is slight level of
2.3.
volatility, because wasn't any normal year, there can be that little bit of fluctuation between the benefits of students and the benefits of universities, you know, depending on what way.
I'm just glad we've kind of noted it. I'm not suggesting we do anything about it.
Chair, I think the historically unusually long period we've had of stable inflation and low interest rates is a huge aberration of the economic cycle, and we've maybe all become really very used to that. There appears to be more volatility on the way, which will need to be factored in future.
Okay. Moving on then to item number 11, which is the SL1, the Employment Act NI 2016, commencement number 4, order NI 2021. There is a clerk's memo at page 208 of your pack, and then the SL1 itself at page 210. This statutory rule will commence the following sections of the Employment Act NI 2016. The power to require party to proceedings to pay deposit, industrial tribunals. Section 7, the power to require party to proceedings to pay deposit, fair employment tribunal. Section 18, 0-hour workers. Section 20, careers guidance. Section 21, apprenticeships. And Section 24, variation in procedures for certain orders and regulations. And Section 27, repeals. The Department is seeking to commence the outstanding provisions detailed above as part of its routine work and to enact the will of the Assembly. The rule is not subject to any formal procedure before the Assembly, and the anticipated date that the rule will come into operation is the 30th of September 2021. So this is the committee's opportunity to consider the statutory rule as laid out in the SL1, or sorry, to consider the policy laid out in the SL1, as it's not possible to amend the rule once it's been made and laid in the Assembly Business Office. Peter, there's no procedure?
It's a rare thing that happens where some statutory rules don't have a procedure. In a case like this, where you had a bill structured the way it was with unanimity across the Assembly, the subsequent SRs have no procedure. So the SL1 stage is really the stage for intervention, because there is no way to intervene with the SR. It might just be worth flagging up. I know it looks odd that they were only legislating on the 2016 bill now, or the 2016 Act, is purely because of the hiatus and the fact that the 2016 bill was at the very tail end of the 2011-16 mandate, and the mini 16-17 mandate didn't provide enough time. Otherwise, this would all have been in place quite some years ago. So the COVID has got in the way. Otherwise, this would have been done early last year. But that's why it's coming so late, and it's coming in a group like that, because we need to get this done before the end of the mandate to allow what's now years worth of work to be put in place.
Before we agree the policy, can we ask for a bit more detail on what those provisions are, because it's not set out in great detail?
No, the details, and I think the particularly interesting looking one is the 0 hours contract. Members will remember that was an issue heavily discussed as part of the 2016 bill, but was timed out and was to be revisited, and is in NDNA, and there is a PMB on its way to the committee sometime soon. Around that. So we'll ask for more detail to just pin all that down.
Members are content.
So the committee can put this off and we can bring it back.
Thank you. So moving on then to item number 12, which is the legislative consent motion, Higher Education Cheating Services Prohibition Bill. The clerk's memo is at page 215 of our packs. The LCM notification letter from the Minister is at page 218. A copy of the Academic Integrity Charter is at page 222. There are responses from the universities and university colleges to the department's consultation on the LCM at pages 227 to pages 238. The bill seeks to make it a criminal offence to provide or advertise to students enrolled at English higher education providers cheating services for higher education assessments for financial gain. The bill does not seek to criminalise students who use the services of these providers and who pass the product off as their own work. However, the bill, if the bill is enacted, a student who solicits the services of an SA mill may be guilty of an offence of encouraging crime, contrary to sections 44 and 45 of the Serious Crime Act 2007. The British Department for Education has since advised that the Secretary of State for Education has asked for the scope of the bill to be extended to include post-16 education. This means that the FE sector will be included alongside the HE sector. This expansion will also have implications for post-16 schools sector, so the Department for the Economy has informed the Department of Education. The committee has written to seek the views of stakeholders, including higher education institutions and student representatives, in anticipation of an LCM being brought forward. The higher education institutions laid out their mechanisms for countering cheating in their responses to the department. All acknowledge that this is a global issue, but not one they feel is particularly a problem here. Queen's and Stranmillis would support the extension of the provisions of the bill. Open University also indicated that it was sympathetic to the aims of the bill. Ulster and St Mary's feel they cannot comment on the extension of the bill as they have no evidence of this being an issue. The committee has not yet heard from student representatives. In the Minister's letter, he indicates he's also written to the Executive for views. He also suggested that the Department would seek to legislate on this issue if there was time. However, given this point in the mandate, he is suggesting piggybacking on Lord Story's PMB. We are not yet aware of the Scottish and Welsh Government's responses, and the Minister cites the 24th of September as the deadline for agreeing that the provisions of the bill be extended to here. So if members are content, we will seek the views of the FE sector, given the possibility that the scope of the bill may be extended to include post-16 education, and to ask for an update from the Department on any responses from other ministers and the Scottish and Welsh positions and the position regarding the bringing of an LCM to the Assembly. So are members content to do that?
Thank you.
So moving on then to item number 13, which is correspondence. At page 241 of your pack, there's a copy of the NI Screen Business Plan for 2021-22. Are members content to note?
Great.
Page 272, there's correspondence from the Committee for Infrastructure regarding the shortage of HGV drivers. And obviously this is an issue that we have already raised ourselves. If members are content to note for now. Correspondence from the ERA Committee to the ERA and Economy Ministers regarding the crisis in the local ports sector in relation, in this instance, to shortage of workers. And again, it's an issue we have raised with the Minister in relation to the shortage occupations list. We had response in relation to that from the Minister.
It's one, Chair, that's actually been looked at from a number of angles, and there's talk about fast courses, conversion courses, and so on. Because this is, this isn't just a local issue. It's an issue that's, it's pretty much global. Because a lot of drivers, obviously, because of the pandemic and so on, lost work, moved elsewhere, and found other work, or are driving for much more, much better terms and conditions on much shorter, kind of shifts and so on.
It's one we actually raised with the Minister when Sinead and I met him a couple of weeks ago, and he mentioned the Department was doing some work around that. So could we maybe ask for an update from the Department in respect of what they're doing to try and alleviate that crisis in HG or in workers? Then page 277, there's correspondence from the EU Affairs Manager regarding the Interministerial Group for Net Zero, Energy and Climate Change. So this is just one to note at this stage. Then there is correspondence at page 279 from the NI Women's Budget Group regarding the skills strategy, requesting a meeting with the committee. So if members are content, we will arrange that. At page 280 of your pack, there is correspondence from Pivotal highlighting policy priorities for the North, and it's just for members to note. And then at items 13.7 to 13.9 at pages 292 to 298, there are letters from Lord J, Chair of the Protocol Subcommittee, with regards cosmetic products, labelling and packaging of substances and harmonised standard for toys. So members are content to note at this stage. And then page 300 of your pack, there's a copy of the ISNI Assembly Committee report. So again, that's to note. And then at page 304, there is the first report of the Examiner of Statutory Rules for 2021-22. So that's for members to note. And then item number 14 is our forward work programme, and it's at page 312 of your pack, and I think it has changed since.
It has, Chair. We'll bring a new one back next week. This one is no longer accurate. We've got bits and pieces have changed, and we've now got other briefings we'll insert because people have come available we weren't expecting.
So just to highlight a couple of things to members, there are some things scheduled on the 27th of October, which is actually Halloween recess, so they will be moved to the 3rd of November. An additional oral evidence session on the bill also have to be included into the work programme. A briefing on the tourism voucher scheme will take place on the 3rd of October. There's a briefing yet to be confirmed on city deals, and we now have a briefing confirmed from the University of Exeter academics on energy policy for next week.
Next week, Chair, yeah.
So you'll get all of that updated in the next pack. And the first informal meeting of this session will be Thursday the 23rd of September with the Queen's Global Food Network, and we have just received that invite during the meeting. So,
true, yeah.
Yep. So item number 15 is any other business, and Sinead has indicated that she wants to raise an item.
Thank you, Chair, for letting me in. And this, I'm aware of this going on for a long time, and it concerns Derry City and Strabane District Council. For a year and a half, the Council has made a request to the Department for Economy to attend the Business and Culture Committee. They've had 3 confirmations of attendings and 3 withdrawals at the last minute. I really am concerned about that. I'm concerned about the culture within the Department for Economy, that they feel that that would be inappropriate behaviour, that they could disrespect a local authority and elected representatives and ultimately the people of Derry City and Strabane District Council by not attending and pulling out 3 times. Once is excusable, but 3 times is inexcusable. And I believe that we as a committee need to call this out. It's unprofessional. And if that culture is and that leadership is given from the department, it's something that we as elected representatives and committee members need to be concerned about, because if it's happening in my local council area, then potentially it's happening right across Northern Ireland, and the department is ultimately responsible and has a duty to brief local authorities on the work that they are doing, and that is it's exactly what the Derry City and Strabane District Council want to do. They want to interrogate about sub-regional targets, ask the Permanent Secretary and senior advisors within the department just what work has been done in and around that. It hasn't taken place. 1.5 years is inexcusable. I know everybody's very, very busy, and I know resources are thin in the ground, but there is absolutely no excuse. It's disrespectful in every single level, and to pull out of meetings at last minute is just not the way to do business. So I want to note that, but I also want the committee to ask for answers from the department as it's concerning that could be a culture that prevails.
Thanks, Sinead, and we will do that.
Chair, we'll put that in the readout from the meeting, that the issue's been raised, and seek clarification from the department as to what the rationale is, why the meetings haven't been, why the meetings haven't gone ahead. It's part of the committee's scrutiny of the department's work.
John?
At last week's meeting in Queen's, we didn't get to the section on the all-island research. Has a briefing been provided yet?
We could get that. I know Professor Greer has a particular involvement. He is the, I'm going to say president, president of the All Island Network. So he does have a briefing prepared. I think we went off track, but we will get that. We will get that brought to committee because I know they have data and so on from that. And I know there's some new partnerships and projects as well, because we'd had a chat about it beforehand, so we'll get that.
Just on that, I have no problem with that coming forward. Would it also be possible for Queen's also to provide any information on what they're doing in terms of links internationally in terms of research, but also then if there's any other particular tie-ins that or networks that are developing, say, within the UK as well, on that basis. So we get a sort of a full picture of the linkages that Queen's are hopefully it's a good news story of that are developing in different places with research in relation to that.
Fully supportive of that, Peter. Fully supportive.
They do have a lot of really positive news on that. You know, they are, as part of the Russell Group, they do a lot of very good international work. So we get an update.
I think as well. I mean, like I suppose part of that is that as I think it was the Vice Chancellor said last week, quite often these sessions are the various sort of complaints, and I think it's useful. Whatever source on it, we can actually get things which are good news. I think that's also useful to know as well.
There's always reluctance to tell us good news. I'm not sure why.
Okay, members, that's us for today. So the final item is the date, time and place of the next meeting, which is next Wednesday at 10 a.m. in room 30. Okay.
Thank you, Chair.
Thank you.
Assembly, Committee Room 30. This is the Northern Ireland Assembly, Committee Room 30. This is the Northern Ireland Assembly, Committee Room 30. This is the Northern Ireland Assembly, Committee Room 30. This is the Northern Ireland Assembly, Committee Room 30. This is the Northern Ireland Assembly, Committee Room 30. This is the Northern Ireland Assembly, Committee Room 30.